Well, I understand your argument under A with respect to things that could be readily converted, but there's also the argument under B, frame or receiver, which doesn't include that kind of language that might bring in artifact nouns more obviously. What's your thought about that?
So I do think there's language in B that gets us there, and it's the fact that Congress referred to frame or receiver but didn't expressly define that term. It's true that in subparagraph A, Congress used the exact language readily converted, but that's because that's Congress's definition of the term, and if it had defined it solely in terms of the functionality of a gun, if it had just said something that functions as a gun, that would be limited to operational weapons. So Congress had a really good reason to use the language there.
Gotcha. I follow all of that.
So then
now moving on to B,
So moving on to B, Congress didn't define the term, which means it carries its plain and ordinary meaning. And we think that the ordinary meaning of a noun like frame or receiver includes objects that are nearly complete but are missing just a few holes that need to be drilled.
Now, we can't possibly think that every noun that Congress uses everywhere in the U.S. Code is used as an artifact noun that carries with it things like Justice Alito's pen and pencil as a grocery list, right? So there's got to be a line that makes this, on your theory of the case, why we should read that into B here, but not everywhere in the U.S. Code. What are your thoughts?
Right. So I want to be very clear that we think that this is a matter of ordinary meaning, that you don't need it to be 100% complete. And that I think that runs across the board. If I mentioned a bicycle, but it was missing pedals, as we explain in our brief, you would still recognize that for what it is as a bicycle. That's the first order question. But then the second question arises that you touched on.
If I'm not inclined to think that every noun is used in that way in the U.S. Code, I mean, that would be a very dramatic argument, right? Lenity, notice, fair notice to people that every piece of paper and pen is a grocery list. You're on notice of that. But is there something particular to this statute that you think would a more narrow approach?
Yes, we think the context and purpose of the statute strongly support understanding the term in this way. And the reason for that is because throughout the federal firearms laws, whenever Congress has itself expressly provided a definition, it has included not only the fully complete and functional item, but things that are the item and can readily be made to function that way. So I think that's Congress's own indication in this statute that it's trying to ensure coverage not only of things that have the functionality of a frame or receiver at the moment they're sold, but frames or receivers that can be readily converted to function with minimal steps.
If you have something textual, I'd love for you to point me to that and also address your friends on the other side, I'm sure, going to make something of this, that as recently as 2021 in a brief filed in the Southern District of New York, the government represented that an unfinished frame or receiver does not meet the statutory definition of firearm.
Sure. So let me take those in turn. With respect to text, what we have, Justice Gorsuch, is the term frame or receiver that's not defined, and the court has many times recognized it needs to interpret text in context. I think the anti-circumvention principle carries a lot of weight here, because if respondents are right and just one undrilled hole is enough, then basically that coverage for frame and receiver has no work.
Does it help that C and D deal with mufflers, silencers, and any other destructive devices that don't have conventional frames and receivers? Does that help you?
I think that that just goes to show that Congress was trying to broadly cover the scope of products that can qualify as firearms, and it certainly refutes respondents' suggestion here that every covered object under the statutory definition needs to have a traditional frame or receiver.
That's what I'm wondering, whether looking at C and D and A, which, as you say, carries some broad language about not just complete items, might be a textual way to narrow and focus on B without saying every artifact noun in the U.S. Code carries this feature.
Yes, I think you certainly could adopt that interpretation, and that contextual surrounding evidence strongly supports our arguments in this case. I don't want to lose track of your question about the brief district court filing in the Syracuse case. I want to be really clear that I think respondents are fundamentally misreading that brief. They suggest that the brief stood for the principle that ATF was arguing that a frame or receiver has to be fully functional to qualify. But if you actually look at that brief, that's not what it says. It walks through the statutory and regulatory history here and makes clear that repeatedly over 5 decades, ATF has always looked at whether a partially complete frame or receiver can be brought to functional condition quickly, easily, and efficiently. So there is no dramatic break in the way that ATF has regulated throughout the entirety of the statute's history.
No, I'll look at that again. And then last question from me, and I'm sorry to take up so much time. In the regulation, it indicates that a frame or receiver, and I'm stuck on this B point, which has been cut into pieces, is still a firearm.
So this
but one that's been shredded is not. Now, I'm not sure what the difference between cut into pieces and shredding is, but perhaps you can enlighten me and help me there.
So this refers to when you already have a fully complete and functional firearm, what steps you would need to undertake to formally destroy that firearm and exempt it from regulation. Those are not provisions.
So it's no longer readily convertible. Right.
So once you actually have already brought something within the regulatory scope of the statute, the statute itself and the agency's regulations require that it be destroyed, which is a specialized term in the firearms industry. I can tell you as a factual matter that the most common way that you destroy a firearm is to torch cut it with 3 specified cuts that ATF has provided guidance about.
This is I'm sorry to interrupt, but this is actually about frames and receivers that I'm talking about, and it's 478.12 C and E.
Yes.
Okay, and it talks about partially complete, disassembled, or non-functional frame or receiver. That's what we're talking about, not the firearm. And again, maybe there's a line a through line, but I couldn't find one between shredding and cutting into pieces. I would have thought that's pretty much the same thing.
So that comes, as you mentioned, from 478.12e, which I should note respondents haven't challenged in this case. It tees up a distinct statutory issue about what it takes to destroy a frame or receiver or a regulated object once you already have a firearm. They aren't challenging that here, and the only thing that is before the court is the definition in B, recognizing that you don't need a fully functional firearm in the first place.
No, but it illuminates what is a sufficiently complete frame or receiver if a complete frame or receiver is not a firearm. And the only way I can be sure that I don't have a fully complete or nearly complete or convertibly complete frame or receiver, and therefore a firearm, is to shred it but not cut it.
Oh, no, let me try to clarify that, because that's not accurate at all. As the regulation itself makes clear, you don't even get to the question of asking whether it's readily converted into functional shape unless you have the clearly identifiable unfinished component part. So you have something that is already well along the way to being a frame or receiver, and that's when you would conduct the readily converted inquiry. And there is nothing in the rule or in the agency's past practice to suggest that anything that isn't shredded or cut up or absolutely destroyed is going to be considered a frame or receiver. That would be entirely inconsistent with how the agency has implemented the statute all along.
Thank you.